Professor John at University. And the title of the presentation is Substantial Requisite Stabilizing Rights for Academic Works, Intellectual Property Law and Functions. And I will go ahead and deal with it.
Good morning, all of you. My topic is substantial requisite of stabilizing rights to academic work. This is sort of a thought about in the sense of intellectual property law. This would be the presentation line of thought. Coming into basics of the intellectual property law, basically we have to understand the nature of the intellectual property law that is the law that has been developed in terms of protecting the creativity of the mankind. Now, particularly in this regard, I am talking about the copyright reflections over this academic work. Now, considered in the terms of copyright, there are three types of works have been protected. Those of scientific, literal, and artistic. Now, coming into the role of the academic, now we can identify the role of the academic in two types of, that of teaching and research. Right. Now here is a certain definition to an academic. Who is an academic? Academics are not merely employees, but also the members of a community of teachers, scholars. That community is constituted in part by ethical commitment to pursue the truth without regard to the implementation of that pursuit for the economic interest of its member employees. To treat universities in the manner of regular employees so as to support the ownership of employee inventions and copyright would undermine the principles of academic freedom and the ethics which constitute universities as well. Now, coming into the protection status of intellectual property in the sense of copyright, now then this is going to be a very theoretical and pretty technical issue that has been raised in terms of the international context as well as Sri Lanka context. Coming into this special thing, now Article 13 of the Fifth Agreement provides the responsibility of the state to confine the limitation exceptions to the rights that are going to be provided. And then coming into section 40, subsection 4 of the Intellectual Property Act of Sri Lanka, it says that the copyright, enjoyment of the copyright would depend on the nature of the relationship of the employment, that of the relationship of employer and employee. Now, with regard to the relationship of the universities and the academy, so that is going to be considered the relationship between university and the academy. Then, therefore, there are some provisions in the prevailing legislation and the Constitution of the Sri Lanka has some kind of substantial or technical barrier in enjoying laws of copyright in terms of this special group, academics, since they are being regulated and facilitated for their research, teaching by the state authority. Now, my research question is whether there is any level of different treatment available to academia in enjoying copyright comparing to other copyright holders, since the most frequently their studies have been funded by the state institutions. Then objectives and methodology. Objective is to clarify the legal possibilities, measures available for the academia in order to obtain equal enjoyment of their rights comparing to domestic and European basis. The methodology could be research and based on qualitative approach. Coming into the discussion part of this scenario, now understanding this nature of the academic and the role of the simply in terms of a contract, it's a contract of employment, but still it has to be, there has to be the guarantee of the academic freedom. And then another case raised up in 2007, it laid a foundation to sort of understanding the generalized nature of the IP right with regard to the Human Rights Act 1998. And that has been recognized the right to possession. As to the Article 1 of the Protocol to the EU Convention for the Protection of Human Rights and Fundamental Freedoms, that has been stated, the protection of property gives every person the right to peaceful enjoyment of their possession. Now, in terms of this right to possession, the term possession also includes the right of enjoying intellectual property and the contractual obligation without being disturbed by other people. And then again, this peaceful enjoyment of the property can be defined the obligation of the party in terms of protecting the nature of the right of possession would be three types of. It may be interfere with the peaceful enjoyment of the property, deprive the person of their possession, or subject to a person's possession to control. And then when it comes to the sui generis nature, in England in 2007, it has been suggested that it should be understanding in terms of just and common sense, because now the British approach is that academic people are very special people and they are very skillful people. Because of that, because of their innovations and thoughts, they build new things and they must be respected rather than the other people. But in the existing context, the legislation does not provide any special room for them to groom as a special crowd, but still, the judicial approach, giving this different interpretations and different judicial approaches, involves them, the role of them is to kind of sui generis. And then coming into the conclusion, when it comes to Sri Lankan context, we do not recognize this right to possession in terms of through a legislative process. And then of course we have a problem with, if we are going to look at on this right to possession aspect, if we are going to implement the right to possession in a way of a judicial activism, then there would be certain contradictory issues in terms of the Constitution, Article 14 and 15. 14 we have that right to choose our occupation, then 15 it gives and Article 15 gives some of the exceptions or the limitations to enjoy those of rights. Then therefore it is necessary to adopt the equitable jurisdiction approach in domestic context if in its case arises, coupled with international standards to promote the platform of the academy to enjoy the academic freedom in terms of copyright, to combat the theoretical imbalance or the debate existing the special nature of the academic community in terms of protecting their copyright without being interrupting their approaches to their enjoyment of